I get this a lot from startup founders. They'll say, I just filed my provisional patent application. That means my invention is protected and I can start pitching to investors without an NDA, right? Well, this is one of the most common and most dangerous assumptions I hear. Help entrepreneurs protect their big ideas. Today, I'm answering an important question for you. Do you still need an NDA after filing a provisional patent application? I'm going to give you this answer through a story. Last year, a tech startup founder came to me. Let's call him Alex. Alex had just filed his provisional patent application. He proudly told me, Mark, we're good now. Patent pending. I can start pitching my idea, right? And he was partly right, but partly wrong. Let's get the technical part out of the way first. Yes, when you file a provisional patent application, a PPA let's call it, you do secure your place in line at the patent office. From a strict patent law perspective, once the PPA is filed, disclosing what's fully described in that PPA will not stop you from later getting a patent for that invention. Alex had done that part correctly, but here's the but. And this is the part that can save your business. Relying only on that patent pending status is a major risk. A PPA only protects the invention, not your business information. When Alex started pitching, he wasn't just talking about the invention. He was sharing financial projections, target customer profiles, manufacturing partners, pricing strategy, and his entire go-to-market plan for that invention. None of that was covered in his provisional patent application. And none of it is automatically protected by being patent pending. But it's still important to protect that information. An NDA protects that confidential business information. The NDA is a clear legal path if something goes wrong. So about 2 months later, Alex called me again. Someone from a meeting where he was pitching his idea had suspiciously launched a very similar product to his. Can I sue for patent infringement, he asked. I had to tell him, not yet. The patent hasn't issued. That can take years, and you've just filed a provisional application. That's not even going to be examined. But if he had signed an NDA, he could have pursued a straightforward breach of contract claim immediately. An NDA gives a direct, enforceable legal remedy that patent pending simply doesn't give you. Pitch meetings also create new ideas that are not in your provisional patent application. I asked Alex, did you talk about any future improvements? He said, of course, the investors love brainstorming. And that's a problem. Those future ideas, improvements, or new features were not in his original provisional patent application. Without an NDA, those new ideas were exposed. He effectively shared those ideas for free. A well-drafted NDA covers not just what you've already invented, but the new confidential information that comes up in the room. So here's what I told Alex, and what I tell every startup founder. Your provisional patent application protects your invention for the purpose of getting a patent. Your NDA protects your confidential business information and anything else that comes up during discussions. You need both. Your provisional patent application is not a replacement for an NDA, and skipping the NDA is one of the easiest ways to lose control of your business. Don't leave your future exposed just to save a few minutes on some paperwork. Using an NDA is standard, prudent, and it's professional. If you're raising capital, discussing partnerships, or preparing to pitch your tech, make sure your intellectual property is protected from every angle. If you have questions about patents, schedule a complimentary and confidential patent attorney strategy session with me. I'd be happy to go over the nuances of how patents can play a role in protecting your IP.